Right, I've opened up the room now and I see everyone coming in, so it'll be just a few seconds and then we'll get started. All right, I have my team checking on Facebook. Make sure that's going well. Okay, let's get going. Hello, everyone. Nice to have you on here again. You know, as the Texas Restaurant Association, do a lot of these kind of educational webinars, so I'm thrilled to have you as part of this. My name is Anna Tausen. I'm the Chief Revenue and Innovation Officer for TRA. We've been hosting a lot of these webinars together, and Ethan and Tally have been part of almost all of them. It seems like we're old friends now at this point. We're going to be talking today about COVID-19 restaurant business compliance. There are a lot of subjects within this that we're going to tackle, and I know we have a lot of questions related to it. If you have a question during the webinar, please go ahead and use the Q&A window or the chat window to chat to me, and I will make sure that we get it asked. If you saw the outline of the webinar, there are a lot of things that we're going to tackle, but if your question comes up and it's germane to what we're talking about right then, I'll ask it at that moment. So don't feel like you have to wait until the end of the webinar to ask it. We are recording this webinar and we are also broadcasting it on Facebook Live. So hello to all the Facebook people that are joining us as well. Happy to have you. And before we get going, I want to turn it over to our sponsor for this webinar. Ben Siddons is here and he's representing Texas Mutual, which is a preferred partner of the Texas Restaurant Association. So if you are a member of TRA, you should definitely look into Texas Mutual as your workers' comp provider. They provide lots of dividends and great returns for our members, and they've been great partners for us for a very long time. Ben?
Thanks, Anna. Hi, I'm Ben Siddons, Vice President of Business Development at Texas Mutual. We're proud to partner with the Texas Restaurant Association for over 20 years now, and we're grateful to be here sponsoring today's webinar. Our mission has always been to create a stronger, safer Texas, and that mission is more important now than it has ever been. That's why we delivered $2 million in grants to nonprofits that are on the front lines of COVID-19, including $50,000 to the Texas Restaurant Association Relief Fund. As the leading provider of workers' compensation in the state, Texas Mutual stands with our policyholders and our communities during this difficult time. You can learn more about Texas Mutual and our partnership with the TRA at texasmutual.com. Thanks for letting us be a part of today's event, and I hope you all gain some valuable information to protect your businesses and your employees. Thank you.
Perfect. Thank you, Ben. I really appreciate that. Really appreciate Texas Mutual's partnership over many, many years as well. So this is our panel for the day, guys. We have some really excellent experts with us today. Tally Parker and Ethan Davis are from Jackson Lewis. Hi, guys. And Jacob Mani is from Mani and Ramirez. These two firms also represent partners within the TRA Law Center. So again, if you are a member of TRA, you do get free legal advice, 15 minutes of free legal advice from one of these partners. And hopefully you'll sign up to be a client of theirs as well. They have tons of expertise and can connect you with any sort of answer you're looking for out there. So guys, thank you so much for being with us today.
Thank you, Anna.
So, thank you. To kick off a little bit, I want to just sort of pull the lens back a little and talk about the Texas reopening. We know that Governor Greg Abbott did a press conference 2 weeks ago to talk about his executive order, General Order 18, which allows restaurants to begin the reopening process. On Friday, May 1st, that's when restaurants were allowed to reopen at 25%, but there were other caps and considerations that they needed to keep in place too. It wasn't just 25% max capacity. It also meant that you had to respect social distancing guidelines and allow 6 feet of distance between one guest and another, not just a tabletop and another table, but between guests it's themselves. There were a lot of other really great guidelines put in place. Many of the guidelines mirrored what we had outlined in something called the Texas Restaurant Promise. And many of you who have been on our webinars before, you are familiar with this process. But the promise was basically something created nearly 3 weeks ago now by working with restaurants around the state, chain restaurants, independent restaurants, data providers, and everything in between to come up with something that we could agree on as restaurant operators to deliver to our guests and our employees. And the idea is to keep everyone as safe as possible. Part of the restaurant promise, of course, was the promise from customers back to restaurants as well. Restaurants cannot do this on their own. We have to have guests willing to participate and follow these guidelines too. And that includes making sure to stay home if you are feeling sick, if you've tested positive for COVID-19, to quarantine yourself as appropriate and laid out by our health partners. And there's quite a few other things in the promise as well. It is available to download in Spanish and Vietnamese, as well as English. So we hope that everyone can take advantage of that. I think it's very helpful. And then if you look on the Texas Department of State Health Services website, they've actually laid out these minimum standard health protocols. And I just wanted to show everyone this website real quick. And I'm sharing my screen so you can see what it looks like. It's this page. It's got the very scary virus at the top. And then if you scroll down a little bit, these are the minimum recommended health protocols. And there are protocols available for nearly everyone. So you'll see right here, we've got retailers, retail customers, and most importantly, restaurants as well as restaurant customers. So if you have questions about what those protocols are for reopening, be sure to go to this website and check it out, and you can probably get your questions answered there. Tally, Ethan, Jacob, anything to add on to Texas reopening before we jump into all the subject we have to cover today?
And one thing I would add is that today I handled a follow-up inspection by the city, and the first question she asked me is, what proof does the restaurant have that they've trained employees about basic COVID compliance? And we were, fortunately we did have some of the posters up, but you do need to, the restaurant protocol, posting that at the workplace is a great idea, because you're going to be asked by, if nothing else, your food inspector, what have you done to educate the workforce? So posting that is a very good idea. It serves no one if it just stays on a computer screen. You need to share that and educate the workers.
Yeah, absolutely. Ethan and Tally?
Nothing else to add.
Okay, great. And yeah, you can actually, and I'll send it out to everyone afterward too. There are some great posters available, like Jacob said, of the Texas Restaurant Promise, and just identifying that. We are also working on a program right now that I can't talk too much about yet, but it is related to education for restaurant workers on specific sanitation practices around the virus and COVID-19 and what to do if you start to feel sick, that kind of thing. So let's start here with restructuring workforce and talk about all the different areas in here. I know that we've answered questions related to this before on furloughs versus layoffs, the shared work program, which we were just talking about before, as well as the PPP updates. So gentlemen, forgive me, I forget who I assigned to talk about this one specifically. So let's just jump into restructuring workforce.
Great. Thank you, Anna. This is Jacob Monty. So we're excited about getting back to work. We just want to cover some basic terminology. Furlough, what is a furlough? We don't use that word very often. It's essentially a layoff, but sometimes it will include the ability to have some employment benefits. The one caveat I want to offer here is, if you allow an employee to keep their insurance benefits but lay them off, make sure that's all right with your insurance carrier. We have been hit with some issues where in the insurance plan, it requires a minimum number of hours worked by the employee. And if you promise the employee coverage, and yet the plan says that they actually have to work in order to get coverage, there could be a conflict. In most cases, it may not be a big deal, but if it's a sick employee, you could run into a situation where you've promised coverage and there is not coverage. So be careful. We are seeing some employers offer furloughs with insurance benefits later to find out that there's actually not coverage. I think we know what a layoff is. A layoff tends to be temporary. It does mean that you're eligible for rehire. A lot of folks are getting recalled from layoff and furloughs, but it is a challenge because some of the employees are earning more on unemployment than they would working. under the limited opening schedule. So it is a challenge. We don't have any silver bullets on how to get people back to work, but we were discussing the shared work program that the Texas Workforce Commission has. This promises to be a good way to have the employees use the Workforce Commission benefits and work a modified schedule. The problem is that it takes some time to get a shared work program approved by the Workforce Commission. So these are some of the challenges employers are facing as they try to get back to work. Callie, do you have anything to add?
Yeah, I guess just a couple of comments I would add there, because you're exactly right, Jacob, that some employees are going to be hesitant to return to work because a lot of them, as you said, are frankly making more money now than they were before or might be when they come back. But I guess one of the things you could do, folks, in having conversations with those individuals is talk about maybe bringing them back part-time, because you might not, from a business perspective, need them back working full-time, right? If you're only allowed to have 25% occupancy, and if that goes up to 50, you still might not need folks working the same schedules that they were previously working. But you can have a dialogue with them and talk to them about, hey, we want to bring you back, but maybe let's have you come back and work part-time, work half of the shifts that you were working, and tell them that that's not going to disqualify them from receiving unemployment benefits. Yeah, they're not going to get as much as they would if they were totally unemployed, but they can still get partial unemployment benefits through the Texas Workforce Commission. And there's a nice calculator on the TWC's website that they can use to plug in their earnings to determine the amount of that partial unemployment benefit. And importantly, at least through July 31st of this year, if they qualify for unemployment, whether it's partial or total unemployment, they can get the $600 a week CARES Act supplement through the end of June. Come back. That's good for morale. Everybody wants to be working. They can be receiving earnings, and they won't lose out entirely on the unemployment benefits that they're getting right now.
That's great, Tally. Thank you for adding that in. The calculator is really important. We have heard from restaurant owners who are saying that they're trying to bring back employees, and some of them are refusing for multiple different reasons. Refusing to come back to work because of being afraid of being exposed to the virus is one thing, but if you anticipate making more money on unemployment versus going back to work, that's quite another. The Texas Workforce Commission has laid out some guidelines for restaurant owners on how to report workers that refuse to come back to work, even though they've been offered a job that they are qualified for. It's uncomfortable to talk about a little bit, but it is essential that employers, they're required to report that back to TWC if someone has refused to come back to work at a job that they are qualified for. So it is definitely important to lay out for employees that they have this option when it comes to reduced hours or shared work, so that they don't think that they're being completely forced to come into something that they don't want to be a part of. And that additional $600 through July 31st, although we've heard that that could get extended, although that hasn't been confirmed yet. So right now that's still in place. On the Paycheck Protection Program updates, this is something that we have been talking about ever since it came out, basically, I think, guys. It's a very complicated piece of the CARES Act. We saw it get funded again through what we're calling CARES 3.5. And I think at last check, 40% of that new fund amount is still available, because so many people, so many business owners have taken a look at the parameters when it comes to forgiveness for PPP and said, no, I don't want to take this money. It just doesn't work for me. We are hearing, though, that there are some great movement. There's great movement happening in Congress this week for bipartisan support of getting the changes fixed to PPP that we need. Just before coming on this webinar, I heard that Stephen Mnuchin was addressing the press as well. I haven't heard what that update is, but there is capability of the Treasury to make some of these changes that we're looking for, including like the 75-25 split and the 8-week deadline. Hopefully that can get changed without Congress, but we'll see. Have you guys heard anything else from PPP updates?
I have not either.
I have not.
It's one of the things that continues going. Okay, so let's talk a little bit Callie and Ethan about the Families First Coronavirus Response Act, which I know feels like happened 2 years ago in terms of how long this pandemic has been going on. But there are some policies that people need to be aware of when it comes to their employees and FFCRA and what it offers employees. So gentlemen, you want to take it?
Yeah, absolutely. Thank you. And one of the things we were just talking about, you know, the restructuring of the workforce and trying to get your folks back to work. And, you know, it's a delicate balance that you guys are going to have to walk, because on one hand, of course, you want all of your employees back, but, you know, under the FFCRA, you guys need to be careful. And if you guys are bringing everybody back, you know, part-time on this reduced schedule, you guys are going to have your entire workforce eligible for these paid benefits all at once. So, you know, as you guys are strategically bringing back your workforce, you guys need to think, you know, and take some time and evaluate, you know, who you want to bring back for how many hours. Because if you guys are bringing back everyone for a couple hours, you know, under the FFCRA, people are going to be eligible for these, you know, for the paid sick leave. You're going to be eligible if you're employed. You're eligible for your entire bank right away. So if you have a full-time employee that you're bringing back for, you know, full-time work, they're going to get their 80 hours. If it's a part-time person, you know, they'll be eligible for how many hours, the average of how many hours they worked the previous 2 weeks. So they won't get the entire 80-hour bank. They'll get whatever they had, you know, as part of, you know, whatever they worked part-time. But importantly, they don't have to accrue that. So in theory, if you guys bring everyone back on, you know, May 20th, all those leave banks are filled up as of May 20th when they come back. You know, they don't have to accrue it over time. All those banks are full. So in addition to that, there's also the amended Fmla leave, where these folks are going to be eligible for paid leave under the amended Fmla. So, you know, it's a consideration how you want to bring back, you know, if you're only able to bring back 25, you know, or have 25% capacity right now, you may only be getting 25% of the revenue potentially, but if you bring back 100% of the workforce in some role, you know, whether it's part-time or full-time, you're going to be on the hook for benefits for all those employees. So, you know, that needs to be a strategic decision as you start bringing back the workforce. That may be, you know, especially if people are, you know, worried for one reason or another. Maybe it's okay right now, or otherwise you'd want to bring back everyone at once. If you guys can get by and, you know, you're operating, you know, at you know, you may want to hold off on bringing everyone back all at once. You know, other considerations that you guys need to keep in mind with regard to the FFCRA, it's the FMLA piece of it, you only get 12 weeks total. So if employees, as you're bringing back these employees, keep in mind what employees have already taken prior to, you know, you guys shutting down for a little bit, or, you know, only doing to-go and deliveries, and now that you're kind of ramping back up. If, for example, an employee in January took 8 weeks of FMLA, you know, January, February, they took 8 weeks of FMLA, they're only eligible for 4 weeks of amended FMLA. So they're not going to get all those, they're not going to be eligible to get all those paid weeks. You know, it's not 12 weeks of regular FMLA plus 12 of amended FMLA. You got to combine them, and it's 12 weeks total. One of the other, you know, with regard to FMLA, you need to keep in mind that there's different standards of who's a covered employer, who's an eligible employee. So just because someone is eligible for FMLA under the FMLA as you know it, that doesn't mean that they're going to be eligible for the paid FMLA, which is what the FFCRA covers. And the paid FMLA is only the specific instance of childcare is unavailable, you know, the daycare shut down, the nanny is sick. Those are, you know, it's that carve out. That's what the amended FMLA is supposed to cover. It's, you know, the childcare is not available. So, you know, an employee who normally has, you know, a serious health condition who's eligible under the traditional FMLA as we know it, you know, that doesn't mean that they're eligible for paid FMLA leave under the FFCRA. So you guys should be aware of that distinction. So you make sure that, you know, if someone's eligible for pay, they're properly paid. But if someone's not eligible for that, you guys don't want to be paying out all this, you know, all this pay that these employees aren't entitled to. Another difference that you guys need to be aware of for the paid sick leave, it's anyone, who's employed as of that date, they're eligible for the paid sick leave. With regards to the amended FMLA, it's someone who's been employed for 30 days. So regular FMLA, the employee to be an eligible employee needs to have been employed for 1,250 hours during the preceding 12 months. For this, it's much more expansive. It covers a lot more employees. So the requirement's 30 days. Something that's important to note is, say you guys were in operation until March 15th and you're opening again on May 15th. Just because, those are, 60 days in between, you can't all of a sudden say, well, hold on, I don't need to, this employee's not an eligible employee because look at the last 30 days, they haven't worked. That's, the law protects more than that. So if the employee was a full-time or part-time, regular employee who worked, it's 30 out of the 60 days prior to whenever you ceased operations, they'll be eligible for the amended FMLA moving forward. So if you have someone who's, regular full-time or, works 4 or 5 days a week in February, just because you shut down in March and open back up in May, they'll still be an eligible employee under this. So be careful of, if you're one of those restaurants that ceased operations or, told certain waitresses or waiters, don't come in, we're only doing to go right now. They'll still be covered employees when you guys open back up, assuming they would have been a covered employee before you guys shut down.
That's really helpful, Ethan. Thank you. We got a question from Juanita in the Q&A window around how does the normal end of school affect FMLA, which is a really good question. We know that, that's been basically no one's coming back to school, right? And so if school would normally be out at the end of May and people would have to have come up with childcare solutions after that, do employers still have to pay FMLA after school is out?
That's a good question. I don't know if that's specifically addressed, but the language that they talk about is the closure of childcare. So it's the employee caring for their son or daughter if the school or place of care for their son or daughter has been closed, or the childcare provider of the son or daughter is unable because of COVID-19 precautions. So, I think that's definitely a tricky area because you're right. There's normally a gap between, for example, the end of school and summer camp, and that might be the week that the employee works a little bit less, or they figure out kind of part-time arrangements. But it's tricky right now because of all of this. I would err on the side of caution if your employee is coming to, if it's kind of a week gap or something, and your employee is coming to you and saying, I need to provide childcare. My day, my kid who's normally in school would be going to the summer camp starting the week after. I would think that, I'd err on the side of caution and say that probably falls under the FFCRA's purpose, which is, helping out these employees if they don't have childcare.
True. And I know we're seeing announcements more and more that some of these summer camps are not going to be operating this summer. So it's going to extend basically all summer, I imagine.
Yeah.
So
yeah. And
what happens after that, right? What happens if an employee has exhausted all their FMLA and their kid still has nowhere to go, and they can't work? Like what's going to happen then?
I think that's going to have to be a decision that the business is going to have to make. I mean, a person isn't going to be entitled to any protected leave at that point. They wouldn't have been entitled to any leave prior to the FFCRA being passed, right? That wouldn't be an event that would qualify for FMLA leave. It's not any type of disability where you get into, do they get leave as an accommodation under the ADA? I think it's just going to be a situation that the employer is going to have to work out with the employee. And, some employers might carry the employee for a while so that employee can stay on benefits, right? And continue to participate in the employer's benefit plans. But if the person's not in a benefit plan and there's really no reason for them to remain on the payroll necessarily, even though they're not being paid, of course, then separation might be the right call for that person so that they then can go out and get unemployment benefits and potentially, if the supplement is still around, get the CARES Act supplement. But of course, if they're, I guess an issue might arise though, and that's for them really to worry about, not the employer necessarily, but an issue could be, do they qualify for unemployment? Because it seems would be voluntarily resigning. In the normal environment, a voluntary resignation disqualifies someone from unemployment. In these circumstances, though, I could see the TWC saying, no, we're going to be a stopgap for individuals in this situation. We will let them get benefits. But from the employer perspective, they're not entitled to anything after the 80 hours is exhausted.
And just to piggyback off that, a lot of good points there. But I think one of the other things that you guys need to be careful of, especially as people are exhausting their FMLA, exhausting their paid sick leave. If someone leaves restaurant A because they're out of, they've exhausted their paid leave under the FFCRA. If they then go over to restaurant B, your restaurant, that paid sick leave bank doesn't come back. The paid sick leave bank is for each employee, not for each employer to provide to each employee. So if John Smith works at restaurant A, he uses up his 80 hours, leaves, goes to your restaurant B, you don't owe John Smith that full 80-hour paid sick leave bank just because you hired him. So when you're hiring new employees, especially as some employees are refusing to come back or don't want to come back, they're scared to come back, and you guys are hiring outside of your previous workforce, you can make sure and see what if these employees have already used these benefits. They're not entitled to these benefits just because they're coming over to you, and you want your workforce to get back up. Hopefully it's the same people you had before, but if you're hiring new people, you're not going to be on the hook to pay let these employees double dip. So if they've already used their paid sick leave at one place, they can't then come over to you and try to double dip again.
That's very helpful, Ethan. Thank you. Thank you for that distinction. Let's move on to talk a little bit about how to prepare and some safety measures that have been laid out. Jacob, would you mind talking a little bit about the governor's orders versus the local health departments? I know this is a question we get a lot, and the governor did discuss, overruling local health departments' orders. So Jacob, can you talk a little bit about that?
Sure, absolutely. One thing I just wanted to mention though, regarding leave, remember, if you have more than 500 employees, this is one area where large employers actually got a benefit that they didn't have to offer this paid leave. And that is somewhat schizophrenic. I don't know, Tally, what do you think? But it's actually the large employers actually were exempted from the paid leave and the FMLA. And that is a little unusual, but it certainly large employers of over 500 employees certainly have more flexibility. Just wanted to note that. Yes, back to safety, and it's hard enough to reopen and deal with staffing issues, but we have a mandate from the state, which is pretty exhaustive, but we also have counties and cities that have their own regulations. In some cases, they are perfectly aligned, but there are certainly an opportunity for there to be a conflict. The main guidelines from the state involve training employees on cleaning and disinfecting, screening employees, having employees wash hands upon entering the business, certainly mandating social distancing, and then the issue of masks. I know masks have gotten somewhat political here, but at least from a restaurant point of view, they are highly encouraged. And I heard it today from Ms. Thompson from the city of Houston. The first question she asked following, we reported a positive employee, and we reported that yesterday. She was at the restaurant today conducting a follow-up investigation. You restaurateurs need to understand that. Once you make a positive report to the city or to the county, you will get a follow-up inspection by the city or the county health inspector. And the first question she asked was, are you requiring employees to wear masks? Do you have hand sanitizer available for employees? She also asked about basic training and protocols regarding COVID compliance. So you have to understand that you are held to the obligation to train your employees, especially now. Regarding the state requirement, remember, you can't have tables of more than 6 people. And as Anna said, the parties must be seated 6 feet apart from one another. Pretty much self-service is out the window. today, Ms. Thompson was upset that the restaurant had a self-serve container of milk. Self-serve is not permitted right now. Single-use condiment portions and disposable menus. Again, restaurants are having a challenge to reopen, but they're also having to deal with the state mandate and then the city and sometimes county mandates. And then also, you can't forget the CDC guidelines, which are also applicable to restaurants as well.
Yeah.
One thing that I just wanted to mention, I can't emphasize this enough. The biggest question that we're getting from inspectors when they come in is, do you have the conditional employee or food employee reporting agreement? This is where the employee signs. This is in the pre-COVID days when you had to have the employee acknowledge that if they were symptomatic of a certain foodborne illness, they agreed that they weren't going to show up to work. That's the first acknowledgement that the inspectors are asking for. So a lot of restaurants maybe don't have that, but it's a requirement universally in every city, in every county in Texas. And having that signed by the employee is vital. And basically, it goes to the issue that if you're sick, the state certainly does not want you working at the restaurant. We're lucky that COVID does not appear to be a foodborne illness, but this is an old pre-COVID requirement, but it's still very much on the books, and you will be asked about it. So as you consider reopening, make sure you have that conditional employee, food employee reporting agreement, because it will come up.
That's helpful, Jacob. Thank you. Related to some of the areas that are being opened in restaurants, I know we got a question from Sue earlier, and then we'll dive a little bit more into daily screenings, but I haven't seen anything related to reopening kids' activity play centers at restaurants. I know that anyone who operates games within restaurants, like a Dave & Buster's type of thing, those kinds of experiential or entertainment things are still shut down and likely will be for some time, but I haven't seen any guidance related to a timeline of reopening those. Have you guys?
No, I haven't.
I have not, and I would think that it would come very later in the reopening process.
Yeah.
If they're not allowing self-serve creamer, I have a hard time believing that they're going to allow any sort of recreation inside a restaurant.
I agree. I'm sorry, Sue. I think that they're right. That's probably going to be one of the last things that gets reopened, frankly. It's just too hard to keep it safe for people, and we can't have like one person, sanitizing after every single person touches it. It's just too difficult.
I think on that, I guess what you could look at, and I haven't seen any guidance on that issue, but I know that as part of Governor Abbott's order with museums and whatnot being able to open, right? It was, yeah, they can open, but the interactive exhibits, anything, those portions are going to remain closed. Those can't open yet. I think it's really the same analysis with respect to this, right? So I just, restaurateurs could kind of follow along with that guidance with respect to what happens with libraries or what happens with museums if specific guidance isn't ultimately put out there.
Yeah, agreed. So let's jump into daily screenings a little bit, because I know this is a question that comes up a lot. And Ethan, I'd like for you guys to handle this, because I know you talked a lot about what these daily screenings look like, the EEOC guidance related to it. So talk a little bit about that.
Yeah, I remember the first two webinars with the TRA right back in March and then early April, getting lots of questions with respect to what can we ask employees? Can we ask them, do they have these symptoms? Can we have them fill out questionnaires? Are temperature screenings permitted? And I think at the first webinar we did, we were giving our best educated guesses and looking at what the EEOC guidance was with respect to past pandemics. But fortunately, the EEOC has come out with guidance on this issue, and they continue to update their guidance regularly. So do visit that often. The EEOC has said is, yes, You can ask your employees when they report to work each day, do they have the symptoms related to COVID, right? Do they have shortness of breath, coughing? Have they lost, smell or tasting, just the normal symptoms? You can do that. You can also have them take their temperature each day before they come to work. You yourself, as an organization, can do temperature screenings at work. If you're going to do that, though, I would, of course, have someone who is properly trained in how to take the temperature screenings. And then any of that information that you do get from the employees, be it in relation to their symptoms or in relation to their temperature, make sure that information is being kept confidential, right? Because there is obligations under the ADA that is medical information. You have to keep it confidential. And also, to the extent you're going to store it, it shouldn't be placed in an employee's personnel file. Medical information should always be housed in a separate file, a medical file. And the EEOC has told us that you don't have to have a separate COVID file for each employee for this paperwork. You can put it in the normal medical file that you would have had for them if one existed prior to COVID arising. But I guess the challenge here is, what are you going to do? Are you going to realistically take people's temperatures each day? That might not be feasible for all of the organizations. And so, again, one thing to consider is perhaps having folks take their temperature at home. And if they have a temperature that is high, to tell them don't come to work and to let us know that, right? That's something that you can do. And then you can utilize the questionnaires, as I said earlier, but I think you do want to be doing something for multiple reasons. Number one, under OSHA, you have an obligation to provide a safe workplace for your employees. So OSHA says you got to provide a safe workplace. These are things that you can do to demonstrate that you are making efforts to provide that safe workplace. You also want to do it because I think frankly, it's a good business practice. It's going to make people like Ethan and myself, when we go out to eat at restaurants. I went out on Saturday and Sunday of this last week, first time to go dine in at restaurants. And, I'm looking around being perceptive. Does everybody have masks on? Why did 9 people, but not this person? What's the deal with that? People are going to be looking at what you're doing. And if you're able to post maybe a notice on the front door, we know those don't always get read, but if you're able to post a notice or to hand something out with that disposable menu that says, these are the things we're doing, you're going to make your customers feel more comfortable. You might get positive publicity around it. So there's business motivations to be taking those steps as well. But then finally, I'm going to talk at the end here about, probably something we're going to be dealing with for the next couple of years, and that's going to be lawsuits coming out of all of this. And steps that you're taking now, again, to provide that safe workplace, but also to help you economically in getting customers, might put you in a better position if you unfortunately find yourself defending a lawsuit, because you can say, look, we weren't negligent. We didn't just recklessly reopen. We followed government guidance, and on top of that, we took these steps here. And if someone did somehow contract COVID, be it an employee, be it a guest, you can show that you were taking measures, you were being proactive, and you were acting reasonable under the circumstances. So those are reasons why having some sort of screening process in place makes sense, I think, for all of the organizations. Topic C here on this slide refers to COVID tests. Again, that was something folks started asking as well. We can take temperatures, but can we actually test people to see if they're positive or not for COVID? The EEOC came out in late April, I believe, and said affirmatively, yes, you can do that. But let's talk practically, right? Like, where are the tests? That's the issue we keep hearing just around the country for individuals who want to go get tested, right? How are the employers, how are small businesses supposed to get their hands on the test? So in reality, yes, testing is fine. Yes, you can do it. I think but from a practical perspective, it's going to be, how do I get the tests? And if I do get the tests, am I supposed to test people every single day? Or maybe I'm going to do it on a rolling basis. Maybe I'm going to test a certain group of the restaurant so that I can manage the spread of it. Maybe I test only those who work in the kitchen on Monday, Wednesday, and Friday, and I test the hostesses or the waiters on Tuesday and Thursday. Perhaps there's some way to spread out the tests, but the test is only going to tell you whether that person has COVID as of that day. They could go out and do something that night or the next morning, and the test result you got on Monday is worthless on Tuesday. So yeah, the testing is legal, is permitted by the EEOC, but I think you're going to really have to deal with the issues of availability of testing. This is a very invasive test, right? It's sticking something up somebody's nose, at least now, which is invasive, and folks probably aren't going to want to have to do that every day. I sure wouldn't. And then it's just, how many of these tests do you have? And again, if you are going to use them, just with the information with respect to temperatures and symptoms, you got to keep the information confidential and only share it with those who have a need to know and maintain it in a safe file.
Yeah, thank you for that. On the screenings part is too, included in the Texas Restaurant Promise that we put out, there is a screening questionnaire that people can use for employees. And again, it's been translated to not only in English, but Spanish and Vietnamese as well. We've seen some restaurants use things as simple as SurveyMonkey to ask their employees these screening questions every day, and it keeps a record for them that they keep, private only available to the HR professionals in their organization. And then other people are also incorporating this into their point of sale systems, where people are able to answer these questionnaires as they clock in for work. So that's another option as well. We're gathering a list of these resources for people too, so that we can send them out. But those are just a couple options. Related to PPE, and I'm gonna keep us moving because I know we've got the big important question coming up. We have gathered, the TRA has gathered a list of PPE resources online. It's on our coronavirus guidance page. You can go and take a look there. We've pre-screened all of these different companies to make sure that they actually have product available so that can be ordered now. So I know we've had some issues with companies having availability of PPE, whether that be face coverings or sanitation, hand sanitizer. We have some companies listed there that can handle that. I want to move us ahead because this is probably the most important question, and we've got some particular questions in the Q&A window that I want to follow up around too. But Jacob, on reporting a positive case, if your employee gets sick from COVID, what happens next, and what are the parameters involved?
Okay, first off, you should gather the details, figure out what location the employee worked at, when his last day of work is, which employees he worked closely with. And by closely, we're talking 3 to 6 feet for an extended period of time. We know extended period of time means about 10 to 15 minutes. And then you're going to need to quarantine those individuals that were in close contact with that positive employee. Next step, you have to let affected employees know about the exposure. And then the third step would be to let the health department know. This is what the CDC recommends. It's important for a number of reasons. Number one, we're in a regulated industry, so we have to deal with the health department. So it's better that the health department find out from the restaurant that our employee was positive than hearing from Parkland Hospital that our employee was positive. And I'll tell you another reason it's important. We had a situation in Dallas recently where, believe it or not, employees were using a false name. Well, Parkland ended up causing a great deal of confusion at a restaurant because they called the restaurant to see if an employee worked at that facility. They said, no, this employee doesn't work here. What had happened is it was a possibly undocumented employee who had used a false name. It's better for you to turn in the information on the employee to the health department directly. Otherwise, they will follow up, and it could create a big controversy as to, no, that employee doesn't work here. The health department will follow up and will make sure that you have quarantined that employee. So we certainly recommend telling the health department yourself. They're not going to freak out. They will send an inspector, but before that, you should clean the facility. Now, you don't have to use an outside cleaner, but I know we skipped over PPE, but the main reason we recommend you using an outside cleaner is that we as restaurants don't have enough PPE in terms of gowns, in terms of masks, in terms of gloves to adequately protect our own workers after a positive test from an employee. So that's why we recommend using an outside service. You don't have to per se, but again, the biggest reason is there's a lack of PPE available right now. And it's also for what Tally mentioned earlier, the lawsuits. You can imagine an employee who was forced to clean following a positive diagnosis. They could have a great claim, especially a lot of restaurateurs are non-subscribers. so they don't have comp, they don't have Texas Mutual, they're protecting them with the workers' comp bar. So if you're going to have your own employee clean up and disinfect following a positive employee indication, you're going to be exposing yourself to unnecessary liability, especially since the cost of outside cleaners has come down dramatically. We've been using a number of ServPro franchisees. You can shop it around. The prices have come down. We're using an outfit in Dallas named Premier, but the prices have come down, and that's good news for restaurateurs. How long should you quarantine the employee with a positive? Well, we now know that it is up to 10 days. It could be up to longer, but right now it's 10 days. And again, if you're covered by the different leave laws, that's going to be paid leave that's going to have to be given to the employee. But this is a big issue right now, because as more restaurants open up, we're going to have more positive employees. And it's important to have a protocol on how to deal with this, because you want to prove that you followed the different regulations. You want to prove that you reopened safely. And that's also going to help from a morale point of view, because you also have employees that are afraid. And the rumor mill will get working about a positive employee. And it's very assuring if you're telling them, hey, we're following CDC guidelines. We also had an outside service come in and clean and disinfect the restaurant, especially the areas where the employee worked. That helps to set people's mind at ease.
Yeah, that's true. I want to ask a specific question that's been sitting here. Jennifer, sorry it's taken us a while to get to your question, but I wanted to wait till this segment. She asks, I have an employee whose roommate tested positive and is under quarantine. The employee was last exposed to his roommate on May 7th and went to get tested himself. His test came back negative and his doctor said he can come back to work, but according to the governor's guidance, he should not be allowed to return for 14 days. And again, he was last exposed on May 7th. FFCRA says he has to be under recommended quarantine by a doctor to be eligible for paid leave. What should this person tell the employee? Should he come back to work? Should he stay off work?
Well, he definitely can't come back to work without being 3 days fever-free, and that is definitely a minimum. Even though he's positive or he's negative, he should not be allowed to come back until he's 3 days fever-free. So that is definitely the case. It would seem like he would. I would say 3 days. It would be the minimum period of time to keep him quarantined, 3 days from May 7th. He does have a negative. That's good. That would be my assessment.
And it looks like Jennifer just responded. She said that he never had symptoms or fever. So that's good. But yeah, definitely wait until those 3 days have passed and then should be able to come back to work. Related to that, if an employee tests positive for COVID-19 and the owner goes through all these steps, the potentially exposed employees, do they get paid leave while they have to go off in quarantine and need to be away from the potentially exposed employee?
Well, if they're covered by the leave, if you're talking about an employer with under 500, yes, they are going to be eligible for that leave.
And I think for that too, just to jump, I think that's right. And there are specific, reasons that are delineated in the FFCRA. So, for example, in that situation, you would expect that if, the employee called their doctor and said, hey, the person I work with, work next to in the kitchen, for example, was just tested positive for COVID-19. You would think that their healthcare provider is going to advise them that they should self-quarantine, which would be a reason specifically identified under the amended Fmla in the FFCRA. So, just because someone in the restaurant test positive doesn't mean that everyone can now leave and they're going to get paid time off. They're going to fall under the amended FMLA. To be eligible to get the paid sick leave or the amended FMLA leave, you still need to fall under one of those qualifying reasons. So before, that needs to happen.
That makes sense. So then what about those employers that don't qualify for that, that have more than 500 full-time employees? What are they doing right now? Are they offering any kind of, I guess it's up to the employer on what kind of leave they're offering.
They are offering, at least in my case, they've offered pretty flexible leave policies, because even though they're not required to offer paid leave, from a morale point of view, it's very important. And I know we're going to talk about it later, but right now employees have a lot of leverage. So just sending them home without, even though they could keep them away from the restaurant without pay, it seems harsh at this point, and not very smart when employees are hard to find right now.
Yeah, that's true. So in terms of cleaning, and I'll come up with a checklist too that maybe you guys can just look over for me quickly so we can get this out the door to people on how to report, a positive case. The positive case is reported, everyone goes home, they're quarantined, the restaurant then gets cleaned. How long should the restaurant stay closed after the cleaning? Like, is there any kind of incubation period that we should be aware of? Is there double cleaning?
Well, the restaurant typically is cleaned at night, so in most cases it doesn't even have to be shut down, and
Sure.
it could reopen immediately. We've had cleanings happen during the day, and the restaurant or grocery store has reopened 3 hours later. So as long as you follow the CDC protocol of quarantining the positive employee, telling the affected employees, cleaning and disinfecting either internally or with an outside service, and reporting the positive to the health department, you've met your obligation, you've followed all of the established protocols, and you'll be in a good position to defend your actions. It's where employers don't have a protocol and they don't react properly that they could face exposure. And we're going to talk about it more, but especially for non-subscriber employers, they do face the possibility of a negligence lawsuit. I know Tally and I are going to talk about it, but there was a lawsuit filed at a sausage company. Walmart has had some fatalities already, and they've been sued for that. The issue of COVID litigation is definitely a real issue, and it's not going to go away. And that's why having protocols and having efforts at education are so important, because ultimately some plaintiff lawyer is going to be able to ask you, well, what steps did you follow? What did you do? How did you educate your employee? And if you can't answer those properly, you could face liability.
So let's move on to that scary part now. So Ethan, as if the rest of this haven't been terrifying already, Ethan, I know whenever we were doing our prep call for this, you talked a little bit about a list of potential lawsuits that a restaurateur could see in the future related to COVID. You guys want to talk about that a little bit before we switch back to Jacob for negligence?
Yeah, sure. So one of the things that our firm did was, I've noted before, we're a large firm, we've got about 1,000 lawyers. And so we just polled, we didn't, Ethan and I, but individuals in our firm polled the lawyers and said, hey, brainstorm, just what are some of the claims that you think are likely to come out of COVID, right? And so from that, one of our colleagues then prepared a Word document just listing all of those various claims, right? And there's, hundreds of different types of legal causes of action that could come out of this. And a lot of them, if there is liability, that ship has sailed. For example, in selecting individuals for lifts, for RIFs rather, was there discriminatory practices employed or not? So a lot of the claims that we might see in the future, the employers have already kind of made the decisions that are going to seal their fate on that. But as we go to reopening now, we think that there's a lot of potential claims that could arise based on actions that our employers are taking now or will be taking in the future. And I just wanted to highlight a few of those. The one that I think is most important, I mentioned it earlier, Jacob's touched on it. He's going to hit on it again here, though, since we're talking about employees. It's just the potential negligence claim, right? The negligence claim that an employee can bring against you if you are a non-subscriber to workers' comp and say that you didn't protect me, you didn't provide a safe work environment, I contracted COVID, either something happened to me or I passed it along, something happened to a loved one. There's going to be a lot of those claims coming out. Jacob's exactly right. I saw Walmart, they were the first, they might not have been the first company sued, but they were certainly the first big company reported of having been sued. And that was, I believe, in early April, maybe even late March, because an individual passed away for Walmart. We're going to see tons of those claims. A couple of the other claims I wanted to highlight are OSHA claims. As I said, you got a duty to provide a safe workplace. So if you're not doing that, even if you are a subscriber to workers' comp, an employee could file a complaint, a whistleblower action with OSHA, and you might be then subject to an OSHA audit or investigation. And then dovetailing with that, if an OSHA complaint is made, you got to be mindful that you don't, and no one, I don't think, would do this intentionally, but that it doesn't look like you've done anything to retaliate against someone who's made a complaint to OSHA or made a complaint to any government agency involving anything related to COVID. Another just claim that I think employers are going to face, practically speaking, I want to mention, kind of noted it earlier, is just you're likely going to be getting a lot of medical information you've never gotten before from employees, collecting information, again, perhaps about their symptoms, temperature, whether they test positive or negative for COVID, if we get around to employers doing those tests regularly. And you're going to just need to make sure you're safeguarding that information, because if you're not, if you're storing that information in the wrong location, if somehow there's a breach, if somehow it gets in the hands of third parties or individuals who don't have a need to know, you might face invasion of privacy type claims. Those are some things that we could envision seeing down the road. And then the other one I really wanted to mention is wage and hour. We do a lot of wage and hour work. That's complying with the federal wage and hour law here in Texas, the Fair Labor Standards Act. And given that you can only operate right now at the 25% occupancy, and even when we get to 50% occupancy, there might not be the need, as I said earlier, to recall a lot of your employees who have been laid off. But you're probably definitely going to have your managers around, because you need them there to supervise the workers that you do have. And a claim that I think we can see coming down the pike is, managerial employees generally, there's not a bright line as to the percentage of duties they should be performing that are exempt versus non-exempt, but that is something that goes into the analysis. Do you have someone who's a manager who's really performing nothing but non-exempt duties? If so, that could signal that they are maybe misclassified. And if they're working more than 40 hours a week, they should have got overtime. So I think we're going to see some FLSA, wage and hour litigation coming out of this, probably some misclassification claims. And then with Ethan's topic that he's talked a lot about, Families First Coronavirus Act, Response Act, you got to make sure that no one is retaliated against or discriminated against in any way for asking for leave or taking leave under that statute, because there's going to be a lot of those sorts of retaliation claims. And then if you are close to that 500 employee threshold, you just want to make sure you get it right in deciding whether or not you are covered and have to provide leave, because I think there'll be some claims coming out of this of employers who said, nope, we're over 500, you don't qualify, we don't have to give you those benefits, when plaintiff's lawyers are going to say, no, you aggregated improperly, you should have given them the opportunity to take leave. So again, some of those ships might have already sailed, but I think that there's, with employees returning, there's probably going to be more of a need for them to take that leave now. And so that calculation is really going to be important and be made now in the future as well.
So Jacob, let's talk a little bit about negligence and then roll into workers' comp.
Okay.
What are you seeing out there?
Well, the big issue is employee would still have to prove that they caught COVID at the workplace, right? And how would they do that? So from an employer's point of view, it's important that we start thinking about getting some information about our employees. Number one, who do they live with? How do they get to work? I'm dealing with a real case right now where we have an employee in ICU, and we're hoping that she gets better, but at the same time, I'm advising my client, try to figure out some basic information. Did she take public transportation? If so, we know that the bus and the transit system is a hotbed of COVID activity. Maybe that's where she got it. Also, who did she live with? Does she live with other people in the workplace? Does she have a relationship with other people in the workplace? Because it can be spread from other means aside from work. So especially for our non-subscribers out there, if you have someone who is positive, asking some basic questions, are you symptom free? How do you get to work? Who do you live with? These are basic questions. Fortunately, we're in Texas where, we're not dealing with California where you could probably never ask these types of questions. I think it's important to start getting a basis in case we have to defend ourselves. And again, this is particularly true for non-subscribers, and we know that a lot of restaurants are non-subscribers. Certainly the best step is workers' comp, because you get that strong workers' comp bar that protects you from these types of claims. But unfortunately, a lot of employers don't have workers' comp, and they have to start thinking about how they would defend against a negligence lawsuit.
Right, that's a good point. So a couple of people have asked in the Q&A window, what happens if, God, there's so many questions related to this, and we'll try and keep it short because I know we're at the hour. But if someone does get exposed to COVID from a family member having nothing to do from the workplace, they still need to go on sick leave, right? They need to, stay away.
Absolutely. It doesn't lessen our obligation to them, but it just helps us from a lawsuit defense point of view to be able to argue, hey, we're sorry you got COVID, but you didn't get it most likely from the workplace. You likely got it from your roommate or your family member who lived with you who showed up positive, before. And this is what you hear in the media about tracing. This is what tracing's all about. Mm-hmm. Asking people when they became symptomatic, how they spent their time, who they spent their time with. All of that is important for us to defend against cases that are likely to arise.
Well, and I'm glad you bring up contact tracing, Jacob, because I know here in Austin, Mayor Adler has put in a guidance for every restaurant that has fewer than 75 people within it, or any small business fewer than 75 people in it. They actually have to keep customer logs now in order to help with contact tracing, which, okay, fine, it's one more thing that people need to do, but we don't see any science right now that says that restaurants are more dangerous than someone visiting an H-E-B or a Home Depot. And so to do contact tracing or customer logs in one type of business, but not customer logs in another, seems very strange and seems almost to be a setup for restaurants, because if there's no other record, right, that's kept except for restaurants are going to be the ones that people point to. That will be the headline, right?
Absolutely. No, I think that we're a big target. We always have been a big target, and there's nothing we can do about that. But I could certainly see how it could be used against us. In the case of an employee, though, I think it could be used as a way to defend a restaurant against a claim that infection happened at work. There's lots of places that infection could have happened aside from work.
That's so true. So true. So also, Jacob, if you don't mind, afterward, I'd like to get a list of these questions that maybe we can ask employees so that we're able to keep these kinds of records. That would be helpful for people.
Absolutely.
Okay. So let's briefly talk a little bit about morale and union issues. This is a tough time, right? It's hard to have these kinds of conversations with people, but we have to be realistic about keeping our business open and successful. It touches a lot of people. So Jacob, I know you've touched a lot on morale lately. What are you seeing with your clients?
Well, look, I think we're in the 1970s all over again. We have the possibility of unrest in America, commodity shortages, and I think we could see strikes, either spontaneous strikes without a union or even strikes by unions. We're seeing it at the meat plants. Fortunately, Texas has been immune from a lot of this labor unrest, but it's important that restaurants understand that employees can unite with one another and engage in protected activity. And if they do that, you can't fire them for it. We were somewhat worried that we were going to see wildcat strikes on May Day. We've seen May Day strikes before in favor of immigration reform. Fortunately, it was pretty tame this last May Day, but certainly employees have more leverage than they did before. Few employees in the workplace gives them more leverage, and will they exercise this leverage? I don't know. I've been heavily involved in fighting the fight for 15 for different restaurant clients. We know that unions do know we exist. They have protested fast food establishments in Texas. So the question is are unions going to jump on it and try to capitalize on this? I hope not, but certainly we have to be prepared for it. And I think it's important to understand also that that's why being nice is such a good policy, because little things tend to turn employees off. Little things also make them happy. The food that we give our employees is a big benefit that they appreciate. Maybe emphasizing that now, that's something we're doing already, but it's important to keep morale in mind in this critical time.
Yeah, that's so true. Ethan and Tally, any thoughts on that related to, some of the clients that you're working with, morale or unionization?
Yeah, I mean, Ethan and I primarily, just given that we're in Texas, we primarily do employment law, not labor laws. As we were talking about before we went live here, just not a lot of unionized employers in Texas. So we focus primarily on employment. But a point that Jacob made there is absolutely correct. We had a labor lawyer who retired in our firm last year. He's with us for 40 years. He did nothing but labor in Texas. And a point he always made at his seminars was look, you want to talk about union avoidance training? We do that. We're great at it. But let me tell you, if you want to save some money, the best way to avoid your place being unionized, to having the unions come in, is to treat your employees well. Treat them well, deal with them fairly, be honest with them, have open dialogues with them. That's the best preventative practice you can have. And so Jacob's absolutely right on that.
That's so true. So true. We've actually encouraged a lot of our members and non-members around the state to show employees, show them the promise, show them what you're trying to do to keep people safe, teach them about additional cleansing practices, what to do if you get sick, and really ask them how they're doing. I mean, this is stressful. It's not just a physical stress, it's a mental stress as well. And there are a lot of resources out there that employers can be given to their employees to show that they care. So I hope that everyone listening to this does take that to heart, is being hospitable doesn't just end at the customer, right? It has to go to your employee as well. Guys, we have filled up more than an hour, which I knew we would do. We got most of the questions answered. I apologize, everyone, that I didn't get your question answered. I will send you additional resources where you can find the answer. We've done a webinar specific to PPP. We've done 2 webinars now with Texas Workforce Commission. We've done 2 webinars with Ethan and Tally before on diving deeper into FCRA. I'll send out all of those resources. And again, if you are a TRA member, you do get the benefit of actually talking one-on-one with these guys who clearly know a lot about what's going on in our industry right now. So thank you, Ethan, Tally, and Jacob, for being part of this today. And everyone will post the recording soon.
Thank you.
Thank you for having us.
Thanks, guys.